Good morning, friends. Let us understand how the doctrine of merger is applied. To know this doctrine of merger, the principles for applying the doctrine of merger, particularly in exercising special jurisdiction under Article 136, we have to explore one of the judgment, that is Konhaya case. But before understanding the applications of principles for merger and res judicata, we have to understand the effect of exercising discretion in different situations by our Honorable Supreme Court under Article 136 of the Constitution. So, I am going to discuss different situations and how the doctrine of merger is applied. What happens, friends, while hearing the petition for special leave to appeal, our Honorable Supreme Court sees whether the petition should be granted such leave or not. So, while hearing such a petition, the court is not exercising its appellate jurisdiction. It is simply exercising its discretion, that is, discretion to grant or not to grant leave to appeal. So, friends, the appellant is still standing outside the door of entry through aspiring to enter the appellate arena of the Supreme Court. Whether he enters or not would depend upon the decision of his petition for special leave. Friends, if the petition seeking grant to leave to appeal is dismissed, it is an expression of opinion of the Honorable Court that the case for invoking appellate jurisdiction of the court was not made out. Now, second situation comes if the leave to appeal is granted, the appellate jurisdiction of the Honorable Supreme Court stands invoked. So the door for entry in appellate arena is open. So the petitioner is inside the door and the respondent may be called upon to face him. Though in an appropriate case, in spite of having granted leave to appeal, the court may dismiss the appeal without giving notice to the respondent. So, friends, in spite of petition for special leave to appeal having been filed, the judgment's decree or order against which the has been sought for continue to be final, effective, and binding as between the parties. So once leave to appeal has been granted, The finality of the judgment, decree, or order appealed against is put in different situation, though it continued to be binding and effective between the parties, provided it is a nullity or the court may pass a specific order staying or suspending the operation or execution of the judgment, decree, or order which is under challenge. Now, friends, as far as the question of applicability of doctrine of merger and rescue judicata is concerned, Honorable Supreme Court has reviewed and summed up in the law as to such application. So, keeping in view the Konohea Madhya case, I am reading out the doctrine. It says, where an appeal or revision is provided against an order passed by the court, tribunal, or any other authority before superior form, and such superior form modifies, reverses, or affirms the decision that is before it. The decision by the subordinate court merges in the decision by the superior court, and it is the latter which subsists, remains operative, and is capable of enforcement in the eyes of law. Second situation is the jurisdiction confirmed by Article 136 of the Constitution is French divisible into two situations. The first situation is up to the disposal of the prayer for special leave to file an appeal. The second situation commences if and when leave to appeal is granted and the special leave petition is converted into appeal. So, the doctrine of merger is not a doctrine of universal or unlimited application. It will depend on the nature of jurisdiction exercised by the superior court and the content and subject matter of challenge laid or capable of being laid shall be determined of the applicability of merger. The superior jurisdiction should be capable of reversing, modifying, or affirming the order put in issue before it. Friends, under Article 136 of the Constitution, the Honorable Supreme Court may reverse, modify, or affirm the judgment, decree, or order appealed against while exercising its appellate jurisdiction and not while exercising the discretionary power disposing of petition for special leave to appeal. So the doctrine of merger can therefore be applied to the former and not to the later. An order refusing special leave to appeal can be non-speaking or speaking one. So in either case, it does not attract the doctrine of merger. An order refusing special leave to appeal does not stand substituted in place of the order under challenge. All that it means is that the court was not inclined to exercise its discretion so as to allow the appeal being filed. If the order refusing Leave to appeal is a speaking order. That is, gives reason for refusing the grant of leave. Then the order has two situations. First one is the statement of law contained in the order is a declaration of law by the Honorable Supreme Court within the meaning of Article 141 of the Constitution. Second situation is other than the declaration of law, whatever is stated in the order will be findings recorded by the Supreme Court, which would bind the parties thereon and also the court, tribunal, or authority in any proceeding subsequent thereto by way of judicial discipline. Honorable Supreme Court, being apex court of the country, but this does not amount to saying that the order of the court, tribunal, or authority below has stood merged in the order of the Supreme Court, rejecting the special petition, or that the order of the Supreme Court is the only order binding as res judicata in subsequent proceedings between the parties. Now, let us go to situation. Once leave to appeal has been granted, and appellate jurisdiction of the Supreme Court has been invoked, the order passed in appeal would attract the doctrine of merger. The order may be of reversal, modification, or merely affirmation. So, if this is the situation, then the order of the lower court will emerge. So, on an appeal having preferred or petition seeking to leave having been converted into an appeal before the Honorable Court, the jurisdiction of the High Court to entertain a review petition is lost. Thereby, that is, as per sub-rule 1 of Rule 1 of Order 47. Sometimes, friends, there is question that when an leave to appeal has been granted, can a review petition be filed under Order 47 CPC Rule 1, Sub-Rule 1? The answer is no. On an appeal having been preferred or petition seeking leave to appeal having been converted into an appeal before the Honorable Supreme Court, the jurisdiction of the High Court to entertain a review petition is lost due to provision by subsection 1 of Rule 1 of the Order 47 CPC. So, friends, the real test which emerges for application of doctrine of merger from the principle which I have read out earlier is that whether the Supreme Court exercises its appellate jurisdiction and has interfered, that I mean to say reversed, modified, or affirmed with the judgment or order of the court appealed from. So, friends, if the impugned judgment or order is interfered with by the Honorable Supreme Court on merit, only then the doctrine of merger applies. So, friends, doctrine of merger applies at the post-leave stage. I mean to say, where leave to appeal has been granted and the Honorable Supreme Court has reversed, modified, or affirmed the order or judgment while exercising appellate jurisdiction, not in any other case. That is, order refusing special leave to appeal, whether speaking or non-speaking. The reason or rationale behind non-application of doctrine of merger is that at this stage, the Supreme Court, while refusing special leave, has not interfered with the findings of the courts below in exercise of its appellate jurisdiction. In the case of order refusing leave to appeal, each speaking one would be a declaration of law under Article 141. Other than the declaration of law, whatsoever is stated in the order are the findings recorded by the Supreme Court, which would bind the parties thereto, and also the courts, tribunal, and authorities in any proceeding subsequent thereto by way of judicial discipline, being the Supreme Court at the apex of the country. So, friends, this is a little bit lengthy video clearing when the application of doctrine of merger applies. So, friends, there being two doors. First door is leave to appeal. Second door is when that is first door is allowed and the petition is converted into leave. So there are two gates which we have to pass through. Sometimes what happens? We pass first door, but later on, during proceeding, it comes to notice of the Honorable Court that he has been wrongly allowed first gate due to misrepresentation of facts to the court. So it can revoke its order of leave to appeal and shut out the first door also. I mean to say the leave can be disallowed at later stage also if the parties are misguiding the court. So friends, we sincere to your pleadings in the petition before going to the Honorable Court. Even in some of the cases, the party has said that whatsoever has been wrongly stated by me due to ignorance of law, no decision of the court has been affected. Still, the Honorable Court said, no, you are not coming before the court with clean hands, so we are disallowing your special leave to appeal. So, friends, be careful while entering first door and to get decision by standing in the second door before the Honorable Supreme Court of India. So that is simple briefing about the doctrine of merger. I hope you are enjoying my videos, and I further hope that you will share these videos to the needy ones, as it is pro bono service. I am not aware who is in need of what. And you should see your circumstantial area, and if someone is in need of the type of videos, please share with him. I will be highly obliged. That's all. God bless you all. See you again. Thank you for watching.